Hi everyone, this is Sean. Welcome back to my channel. Please press the thumbs up button, subscribe, share, comment. I am always looking forward to reading the comments, and I am always looking forward to reading the dialogue. I appreciate all of you guys. Thank you so much. So if you have Instagram, I'm on Instagram too. My profile name is The Firearms Trainer. If you want to connect with me, if you want to ask me questions that I didn't cover in other videos, that's one way how to connect with me. So we have a new subscriber to this channel and to our Instagram account, and he forwarded me this interesting question. He wants me to talk about what type of self-defense techniques can you use as a private security officer. He knows what you can use basically more or less in law enforcement in the military, but he was a little bit confused on what you can use as a private security officer because there's not a lot of blogs that address this issue. There's not a lot of YouTube channels that address the issue. So that's what we're going to talk about today. And guys, again, feel free to throw some questions out to me through my Instagram account. It is called The Firearms Trainer. That means that most of the content is related to firearms. If you don't like firearms, guns are scary, they're evil, and nobody should have them, then don't connect with me on Instagram. If you want to ask me questions through the various videos, through the over 600 or 700 videos that I've posted. You can go back to a video that was made 2 years ago and ask me a question, and I get alerted that you have a question, and I will answer as best as I can. Without further ado, let's get started on this topic. A lot of you out there, you're training on self-defense techniques, either in the military or you're taking some law enforcement related classes. And sometimes you take security related classes and they teach you these techniques. They'll teach you the rear wrist lock. They'll teach you an arm bar or some type of other takedown technique. And you're wondering, can I use this in private security? I'm going to say this. There's a reason why our subscriber was not able to find a lot of YouTube videos, a lot of podcasts that address this question. Because nobody wants to address that question. Nobody wants to say, oh yes, in private security, you're allowed to do a rear wrist lock. You're allowed to do that. I don't know of any video that addressed that issue because nobody wants to be wrong. And I am not going to fall short of that standard in the industry. I'm not on this. If you're looking for this video to address whether you can use a rear wrist lock or some other takedown technique, I'm not going to even address that because I can't. If there's any YouTuber out there that addresses what specific technique you're allowed to do, I would do some more questions. I would ask some more questions of this person's training, their background, their qualifications, because I don't believe anybody should be suggesting a certain technique. What they should be doing is addressing the concept of reasonable amount of force. As a private security officer, you, for the most part, have the same authority, powers as a private citizen. Now, that can vary based on your post. It can vary based on the state that you're in. I'm in California, so my understanding of the laws tend to gravitate towards California. Having said that, what I mentioned in this video is not legal advice, it's not professional advice, it's just my personal opinion. Please get the concept of this video and bring forth the concepts to a licensed attorney, somebody who's qualified to practice in your state. This is just my thoughts. Now, moving forward, just because I'm in California, I will be talking about California law, California case law included. The chances are that if I mention a California Supreme Court case or a California criminal code, the chances are your state has something very similar, if not almost exactly the same. Okay, so as a private citizen, you're allowed to use a reasonable amount of force. Now, unfortunately, the concept of reasonableness is a question for the jury to decide. It's not a question for me to decide, not a question for you to decide. It's a question of the jury. The jury's presented with all the facts if you have to stand trial, and they agree whether or not your use of force was reasonable, whether it was justified. And that's why that there's no videos and podcasts out there that legitimately answer this question, because it's a question for the jury. And the jury breakup or the makeup of them can vary state to state. one jury might say this and another jury might say that. They might say that this is reasonable. Another jury three states away might say, no, that's not reasonable. That security officer should be convicted for battery. And unfortunately, that's the way it works, guys. So I'm going to cite a couple of cases that will drive this concept a little bit more forward. There's a case in California. It's a California appellate case called People versus Randall. This is a 2015 case. In that case, you have the victim and another person chasing down a shoplifting suspect. Okay, the suspect is running away with a laptop computer from the store, a brand new laptop. And what ends up happening is, or what happened was that the victims, they used force, okay? They used a reasonable amount of force per the judge to get the laptop back. But once they got the laptop back, they got back out of the car and they gave the suspect a beatdown. That was not a reasonable amount of force. The court concluded that the first beatdown in order to get that laptop back into control, back into custody from the victim, that was reasonable. But the beatdown afterwards was not. Okay, that was an unreasonable amount of force. Let's talk about People versus Fossaman. This is a 1983 case. This case was heard by the California Supreme Court. What that means is that all these smaller district California courts, they are bound by this California Supreme Court decision. The California Supreme Court decisions are the law of the land in California. And by the way, if you want to be able to speak more articulate, speak more intelligently on topics like the topic that we're discussing today, if you want to be able to provide evidence to your students, to your coworkers, and I'm talking about case law, decisions, make sure that you guys attend my 40-hour online private patrol operator leadership and development course. This case is a case that we discuss into great detail. And we discussed this course during our discussion about use of force concepts. So let's talk real briefly about this case. So there was a suspect who pulled a knife out on this woman. He told her to go back to the building. She didn't know what was going to happen. She thought that something horrible was going to happen, but not exactly what. The point of the matter is that he produced a knife, put it right up to her back, I believe. She was able to call out for help, and there was a whole posse of vigilantes that wanted to save this lady, and I thought that they actually did a good job. So they chased the suspect down. The suspect began running away, turned around, and squared off on one of the victims. And there was like about 3 to 4 victims. I mentioned victims because these bystanders who end up becoming vigilantes, they end up becoming victims because of the suspect's assault. So the suspect ran away, turned, squared off. And what one of the victims did is he grabbed both of the suspect's shoulders like this and brought down his upper torso, okay, right to knee him in the groin. Suspect was able to get out of the hold and broke the victim's jaw. This case was heard by the California Supreme Court. The California Supreme Court ruled on this issue, and they said that the use of force, that the attempt to strike at the groin, was reasonable considering the circumstances. The court stated that they wouldn't advise anybody to do the same thing, to chase somebody down and knee the suspect in the groin. But they decided that was reasonable. The suspect was running away. He was seen with a knife, and these bystanders were attempting to effect a private person's arrest, okay, on this person. They're trying to help the female effect the private person's arrest. Okay, as a private person, you can call for help if you want to effect the private person's arrest, and it looks like that's what she did. The suspect was later convicted, and he appealed his whole decision, and that's how we got the California Supreme Court case that we're talking about. But in that circumstance, force was reasonable. In the People versus Randall, the 2015 case, it was first reasonable when they used force to get the laptop back, but then afterwards, when they gave the suspect a beat down after retrieving the laptop, that was not a reasonable amount of force. In California, we also have California Penal Code 835, and I'm going to read this verbatim. It states this: that a person arrested may be subjected to such restraint as is reasonable for his arrest and detention. What they're essentially saying here is that you can subject, the suspect that is going to be arrested, you could subject that person to reasonable restraint. That means reasonable force. That's California Penal Code 835. These are your justifications. Something else I want to mention, guys, is that what I want you to do is, being a private security officer, try to use the techniques that you're taught. If there are no security officer courses out there that teach hand-to-hand defensive techniques, attend a law enforcement course. Because the law enforcement courses, the self-defense techniques, and the correctional officer self-defense techniques, they're very similar to what private security officer courses offer. Very, very similar. Sometimes it's almost the same thing. So make sure that you restrict yourself, and I'm going to add a caveat to that. Try to restrict yourself to what you're taught. If you're taught a rear wrist lock, then do that. If you're taught an armbar takedown, do that. If you're taught some other takedown technique, then try to stick with those techniques. The reason being is that your attorney can subpoena that instructor or that institution, and they could testify that, yes, this is a technique that we teach at our college, or a technique that we teach at our academy. And they are able to use this if these types of circumstances are present, and they're going to most likely talk about the use of reasonable force. Okay, they're not going to give an example unless maybe it's asked of when you can use this same exact technique, but they're going to generalize when. Now, if you happen to use a different technique, and this happens all the time, then you have to explain that. And what my explanation would be, if I have to give somebody a distraction blow to the face, as long as it's reasonable, okay? If for example, they're running, we have witnesses state that the subject has a knife, the suspect runs away, turns around, puts his hands right in the hoodie like this. Okay, if you end up distracting him by striking him in the face, you're going to have to explain why that's justifiable, because they normally don't teach that at the police academy. They normally don't teach that at correctional academy as well, or any law enforcement academy. So you have to explain why you did that. And what I would explain is, during my academy training, I was never taught what to do if somebody is alleged to have a knife, they're running away, and they spin and turn on me, and they put their hands in their pocket. I was not trained on what to do. So that was the most reasonable force option that I had at the time. And it was the most least amount of force to overcome the resistance, to overcome the threat at that point in time. Okay? You have to be able to articulate your responses. If you have to run after somebody and tackle them, okay, I don't know of any academy that teaches tackling, but if you have to, then I would state, well, first off, in the academy setting, most of the time, our fellow students or the people that we practice with, they're just standing. They're standing on the mat. They're not running away. This is a technique that the academy doesn't address, because they can't address every single technique. And if I was the self-defense instructor of the academy, the arrest and control, the DTAC instructor, I would testify on the same concept, that we cannot teach every single technique because every single circumstance is different. And they would also testify that this technique that they teach at the academy, it's not always 100% effective. Sometimes it's 50%. Okay? On camera, I won't say what the academy's effective rate is, but I will say that many times I have to improvise on the techniques that I was originally taught. And that's so that I go home and that my partners go home at the end of the day. In a real world environment, people who are combative, they're not going to just give you the arm, okay, for an arm bar or for a rear wrist lock. They're not going to go like this, or they're not going to be on the mat and the instructor says go and begin. It does not begin like that. Those of you who've been in the real world and experienced violence, it doesn't begin like that. And you have to articulate that you are trained in a controlled setting. And the academy instructors, okay, that may have to testify on your behalf, they too need to testify that there are so many variables in using different techniques. And I would expect most of them to testify that way as well. Okay, so just in summary, use the techniques that you're taught. In academy, military, you got to be careful though, unless you have a military police, MOS, where it's not like stabbing the person with the bayonet. I mean, I'm talking about to control a soldier, a Marine, a sailor, those techniques, when that military service member, or even the airman, when he's not presenting a deadly weapon to you. I'm sure, I've never been a military police officer, but I'm sure that they teach you weaponless defense and less lethal techniques as well. Now, infantry, I'm sure they teach you all kinds of techniques there. I mean, you can't use all of the infantry techniques on a civilian. You might end up in prison. Okay, so don't do that. Notice I keep mentioning military and law enforcement. Guys, if there is security-related training out there that addresses hand-to-hand defensive techniques, go to that specific security course, as long as it's reputable. If you can't find a security-related course, I'm sure that you can find an organization who that regularly trains law enforcement and start attending their courses. And you can even ask the instructor before you sign up, if I use these techniques in real life, are you willing to testify on my behalf that you showed me a specific technique? If the answer is no, then I would just leave. I mean, I would go to a different place. So that's all I have for you guys. Let me know what your input is. What do you think about this video? What do you think about the content? Take care and be careful.